he mentioned the Dagon.
Sir, in the morning, my lord, may I request one thing, my lord?
Yes.
If your losses takes up the matter relating to appellate side,
Yes.
any day, on the whole of the day, that will be.
No. Which matter you are
No,
mentioning?
I am. I do number.
Matter is
11.
appearing in the list.
My matter. I do number 11. My request to people lordship that people lordship takes up the matter.
For I shall just wait for this today. Next week I shall see.
All right, my lord. Deeply obliged, your lordship.
If I may have your lordships kindly to mention a matter, your lordship. It's an origin side matter. It was slated to appear in your lordship's list yesterday. The matter was returnable, but it hasn't.
Yes, give the slip.
My lord, sorry, my lord.
Yes.
Your lordship again. This is my small application with one prayer, my lord.
Have you filed the application?
Yes.
It will appear.
Department people advised me to.
No. It is. Have you filed the application?
Yes. Computer file.
Very well. You give the slip. It will appear.
किस नंबर का दे दो
ये number. The transmitter. Huh?
On the other side matter to be mentioned item number 1.
Yes. So that. Yes. Record an order.
My lord, may I hand over the order? So, my lords, apart from my lord to
learned advocate for one of the party, learned advocate for the applicant intervener is present. It is submitted that in order dated 23rd July 2025, the name of the learned advocate appearing for the applicant intervener Shebait is not mentioned. Let the name of the learned advocates who represented applicant intervener Shebait be incorporated in order dated 23rd July 2025. Other contents of the order dated 23rd July 2025 remain unaltered.
yes. Shall I already handed over the
Yeah. No, শুধু rectification, incorporation of the names of the advocates. Yes, next.
Item number 2. Round 2, my lord.
By appear for the plaintiff.
Respondent. In this matter, my lord, I'm the judgment data, my lord. My lord, in this matter, earlier there was a lordship's direction to file calculation sheets in this matter since we have deposited an amount of rupees 27 lakhs and odd. Now, my lord, I have sent the instruction, my lord, the calculation sheet has not yet arrived. From
When is the matter due to appear?
matter was due to appear today.
Today, my lord, it's wrongly appearing as
to be mentioned,
to
my
be
lord.
mentioned. It should
So 25/7 for further consideration.
Because your lordship direct.
Calculation sheet is not yet ready.
No, my lord. That is the
on the.
So
We
you have
not-
prepared your calculation sheet.
Yes, my
You have
lord.
exchanged the same.
no,
No, I'm just handing it over to them now. And Lordship, this is on the basis of what we have claimed in our application at the rate of 112 per square feet. My lord. And they are
Anyway, let them consider. Let them give their also calculation.
But my
sheet.
lord, in this matter,
Yes.
My lord had directed to file the calculation sheet as far as
Both
I
the
remember.
parties.
My lord, with regard to the last special referees report, last special referees report was not 112 square feet. Last special referees report was
So whatever you want to file, you please file it. On the next day, I shall consider.
because my lord, this will create a confusion. My lord. Okay, my lord. I will
Record an order.
Lordship, in that case, I'm also filing the
Yes, my lord.
calculation, what is payable to us.
Okay, you give a
based-
copy. Let him submit whatever on the next day.
What is payable to us. in
Learned
terms of the-
advocate for the decree holder files the calculation sheet. Copy served. Let the calculation sheet be filed on behalf of the judgment debtor on or before
My lord,
31
2 weeks time may be granted, my lord, because this authority, my lord.
7/8/2025. Let this matter appear on 12/8/2025.
My lord, time may be
Lordship-
fixed, my lord, kindly, my
Lordship will
lord.
kindly fix it at 2 p.m.
Because,
My lord, let
because
it be
this is
fixed on
hearing
6th.
matter, my lord.
Well, wait, 2025 at 4 p.m.
Let it be fixed on 6th, my lord. I mean, there's some difficulty on the 7th, my lord.
No, I have kept it on 12th.
Oh,
For
12th.
them, they will file their calculation sheet.
Okay, 12th.
Oblige, my
Huh?
Lordship will
4 p.m.,
kindly
4
record
p.m.
that we have filed 2 calculation sheets, my lord.
No. 4 p.m. fixed matter.
Lordship, we have filed 2 calculation sheets. That Lordship will kindly record.
Whatever you have served them,
Lordship.
let them submit there.
বলছে এটা রাখতে বলছে
Item 3.
এটা রেখে
Item 3. Yes, call the next.
Item number 3. Yesterday, my lordship.
When is the matter due to appear?
My lord, due to appeal.
My application.
I know, my lord, yesterday.
Coming up with my instance, I had mentioned the matter.
No,
Mr. Mishra had mentioned it yesterday. This matter was due on the 22nd of July. It didn't appear, so the matter was mentioned. Your lordship is pleased to direct that the matter appear as to be mentioned for fixing the date.
May I say this, my lord?
GA11 is whose application?
I have taken out an application.
11 is an application filed by one of the defendants, my learned friend, for dismissal of a suit. Suit is a declaratory suit which was filed initially. Then pursuant to an order of the division bench, before the single bench, an application was filed for amendment of the plain. Suit was converted to a partition suit. So everyone has a stake. I appear on behalf
That
of
amendment was allowed.
Direction was given to file written statement. This defendant, my lord, who has filed this application, has not filed any written statement. That order has not been challenged. Now there is an application for dismissal of the suit, and
That has to be disposed
yes,
of.
and an interim order was passed, my lord, that the suit should not be transferred to the list of undefended. I have nothing to say. Affidavits are complete. I support the cause of the plaintiff because now it has been converted to a partition suit. Only what I respectfully submit, my lord, kindly fix a time, any date when it is convened in court, so that this can be heard out. I hope nobody will object to this.
So affidavits are complete?
All complete.
Yes.
Kindly fix a time, my lord.
But only one thing, kindly keeps in the second week of August 2025.
No.
For the parties are present as affidavits are complete with regard to GA11 of 2025. Let this matter
Your lordship will place it next week.
appear under the heading adjourn motion on
But second week of August,
Next
Lordship.
week. Your lordship will place it next week because they haven't filed a written statement from 2012.
তারিখে দেখুন তো কোনো ফিক্সড আছে কিনা।
I'm grateful. Any
Yes,
time,
why?
any date, but kindly fix a time.
7 তারিখে 7 তারিখ আর দুটোর সময় 6 তারিখে
My lord, it's a chamber matter, my lord. Order 7 chamber matter. Order 7 rule 11 application.
But maybe in the week which
Either
commences from
Oh,
11th.
that has to be taken up on Tuesday
Either
or Thursday.
Thursday.
Yes.
Any day. I have no
But only
But
one
matter,
thing.
hardly there is any scope to fix the time.
My lord, kindly, my lord, fix the time. My lord,
It's very difficult to fix the time in
I know,
chamber
my lord,
matters.
any day, my lord, any day when it is convenient. Otherwise, so many.
Take it up on the 5th in that case. If
May it appear in your lordship's list any day on the week commencing from 11th of August.
Okay, let this matter appear on
5th of August.
okay, I'm keeping your 12/8
Very well.
2025
Kindly fix the time. my lord. I have no issues with the date.
at 10:30 a.m.
Lordship.
Very well.
I'm
10:30.
grateful.
Your lordship has fixed it at what time?
Yes, 10:30.
Deeply obliged. Deeply obliged.
I'm grateful.
Yes. Let us see, because you see, otherwise there are other matters fixed. It will not be possible to take up then. By simplicity of keeping it will not solve the purpose. Let us see at 4 p.m. No, you just commence the arguments. If it is not concluded, definitely on some other day I'll keep it at 2 p.m. But there are other fixed matters. Simplicity of keeping the matter will not solve the purpose.
And in item number 4, I appear for the plaintiffs, my lord. On 23rd of June, my lord, the witness of the defendant was partly examined before your lordship and the matter was fixed on 15th July at 2 p.m. Unfortunately, my lord, on that day, the bench did not sit.
So
it is-
anyway, you are representing.
I am the
The
defendant number
defendants.
1A and 1B, my lord. My witness was in the box.
So let a
Okay.
date be fixed.
Let a date be
My lord,
fixed.
respectfully praying, if your lordship kindly fixes 2 consecutive dates, then examination in chief will be over.
Anyway, on the
Lordship,
very first day, I shall fix the
Yes.
following day. Yes, learned advocates for the parties are present. The matter is pending under the heading witness action. Let it appear on
My lord will kindly fix a time, my lord.
ছ তারিখে 3টের সময় নেই কিছু না 5 তারিখে
Lordship,
What?
kindly not 6th, Lordship, I am not available on
ওকে তাহলে 5 তারিখ বা 7 তারিখে
5th or 7th, any day.
5 তারিখ আর 7 তারিখে দেখুন তো 5 তারিখ 4টে থেকে আছে আর নেই তাহলে
7th,
yes on 5th at 2 p.m. 3 p.m. 5th August at 2 p.m. Sorry, 3 p.m.
Is it your lordship's pleasure to fix another date, my lord?
On that day I shall fix it.
Lordship, my lord, then the only thing I am worried that it will spill over after the vacation, my lord.
I shall try to see if
Lordship,
so that the evidence is complete.
lordship. I'm grateful, my lord.
Grateful.
এটা ফরওয়ার্ডার্সটা ডেকে দে ফরওয়ার্ডার্সের পরে
Item number 5,
I am for the applicant.
Yes, this application is allowed. Let there be an order in terms of prayer A, B, C, and D of the master summons dated 25/4/2024. The amendment be carried out within 4 weeks and re-verification be made within 1 week thereafter. Yes, call the next.
item number 6,
May it please, madam, this is my application, madam.
Yes.
Madam, sorry. Madam, on the last occasion, madam, had appointed a special officer, madam, the special officer has.
Orders, my lord.
Yes.
Yes, sir.
Thus, upon considering the facts of the case and report of the learned special officer, this court is of the view that the order dated 3rd April 1990 and 1st June 1990 directing maintenance of status quo in respect of the immovable properties of defendant number 2 to 4 should be modified. Thus, this application is disposed by modifying orders dated 3/4/1990 and 1/6/1990 to the extent that a deed of conveyance may be executed by defendant number 4 in favor of the applicant Anil Kumar Sagani of flat being flat number 4G 8B Middleton Street, Kolkata 7,71,000.
Deeply obliged, madam, deeply obliged. Grateful.
item number 7,
GS stands disposed. Yes.
The good case.
Yes. Hence, it is ordered that probate of the last will and testament dated 24/5/2003 of the deceased Sumitra Devi Jagat Ramka be granted to the petitioner as sole executor named therein with effect throughout the Union of India. Let probate be issued upon compliance of necessary formalities.
My lord. I'm grateful to you.
Disposed. সবগুলোই disposed. For orders যেগুলো দিয়ে থাকে সবগুলোই disposed. না এটা তো প্রবেট পিটিশনটাই ডিসপোজ কেসটাই ডিসপোজড হয়ে গেল হ্যাঁ ইয়েস উপর থেকে বললো তো জানি
item number 8,
I am for the plaintiff petitioner.
Yes,
My
Mr.
lord.
Bose is.
Mr. Bose is
conclude the
leading me.
matter.
Yes, Mr. Bose had concluded his argument.
Concluded.
It's for
My learned
defendant
friend.
number 2 minutes.
Yes.
On the last occasion, Millard, I was reading through page number 10, Millard. Page number 10 of their application, the plaintiff's application GA 8 of 2025.
Yes, G8 din.
Page 10, Millard.
Yes.
Look, basically the prayer, Millard, it's relating to a partition suit. The prayer in this GA application, the plaintiff is asking that the allocation of their share relates to a building, a single building, Millard, an engineering center, which should be given at the exclusion of others. And all the defendants can fight among themselves in this pending partition suit, Millard, and that portion of the property be allocated to the plaintiff. This is the basic prayer in this present GA application by the plaintiff, Millard. But kindly come to the third paragraph, Millard, which is capital C. This is their application, Millard, which says, on acceptance of terms of settlement, the parties shall issue letters of atonement informing each of the tenants and or occupiers of the properties not within its allocation regarding ownership of the each properties and persons responsible for collection of rent, occupational charges on behalf of the respective owners. The D, Millard, the parties shall make payment of liabilities towards the said properties within shares within 6 months from the acceptance of the present terms of settlement, and the plaintiffs and defendants shall not sell the properties being subject matter of the suit within 6 months from the date of acceptance. Millard, as far as this last paragraph is concerned, this is which is creating the issue, Millard. What we are saying, being defendant number 2 and even the defendant number 6, 7, and 8 are joining issue with us, that if this is honored, then we are with the plaintiff's, Millard. The 6 months time, that the moment we clear of the dues, the possession will be handed over to us. We said this. Now, Millard, there is a contradiction in the new terms of settlement entered between 1, 3, and 4, defendant number 1, 3, and 4, and the plaintiff's, Millard. Let kindly come to page 80, Millard, 80. Now, Millard, in the petition, they are writing that you take the possession, then pay off your dues within 6 months. Exactly opposite, they have agreed in that new terms of settlement, the plaintiff and 1, 3, and 4. Now, Millard, kindly come to page 10, Millard, paragraph 10, Millard. This is part of their new terms of settlement. Let the defendant number 1, 3, 4, and 5 shall within the next 6 months from the date of acceptance of the present terms of settlement make payment of their proportionate liabilities due in respect of premises number 71, 72, and 73 Bentinck Street, Kolkata 1, directly to such authorities, namely the Kolkata Municipal Corporation, income tax authorities, and the liabilities toward gratuity payment payable to the staffs, and upon clearance of all the dues, the defendant number 1, 3, 4, and 5 will take possession of their respective shares. Now, Millard, this is what is creating the issue. Why, Millard? Millard, kindly see that the partition is happening of an estate, Millard. The dues relates to an estate. Now, this clause makes it...
whether the dues relate to the suit properties.
Suit properties, Millard.
Yes.
An estate which is required to be dissolved. The property was in the name of a estate, Millard. Now, the dues relate to the entire property in the name of that AC estates. Now, because of that, this problem is cropping up, Millard. No one can pay in part and parcel because the property is not, Millard, proportionately divided among the names have been entered of the respective owners, Millard. So the KMC or any other authorities cannot say that this defendant who will be occupying this much of the property or this floor of the property is having so much of dues. Now, for that, Millard, we have been making application, which is the natural course of a partition suit, that what happens, Millard, the owners come together or some of the owner come together and file a partition suit. It has been admitted, preliminary decree passed. The learned commissioner is appointed, Millard, to say whether the property is partible or impartible. In this case, Millard, the property is partible. They entered into a terms of settlement, but it was never honored. For this reason, Millard, we took out application because there are rent dues also, which was payable from the 1 and 4 defendant number 1 and 4 to us. That is a separate story, Millard. Millard, what has been asked in this application is unnatural to a partition suit, Millard. In a piecemeal process, they are asking that, and Millard, why, Millard, this Western Street, which the plaintiff is asking, it's a standalone building. They will take that standalone
You are
building.
not a party to the terms of settlement.
My lord.
So what is your stand? That is which page?
Millard, to our opposition, Millard.
Yes.
Millard, kindly see the opposition of the defendant number 2, affirmed by one Rashina Ahmed, Millard.
Yes. Affidavit in opposition টা দিন তো।
Okay. Millard, at page 10, Millard. Page 10, paragraph 8, Millard. This is our stand, Millard, in simple terms. Millard, to ensure clarity, the paragraph starts from to ensure clarity. All parties and to expressly state my position, the following facts are placed on records. I am ready and willing to be part of the settlement if upon execution, all parties will be handed possession of their respective shares regarding of any outstanding dues, or a special officer be appointed by this honorable court to collect the respective dues of the respective parties and shall allot possession to the respective parties immediately on payment of their dues. Millard, in effect, Millard, I am agreeing with the plaintiff, which should naturally be the course, Millard. What will happen if I pay the dues in the hands of 1, 3, and 4, defendant number 1, 3, and 4? How will I pay the dues, Millard? For that reason, now our specific contention in all the previous application is the entire property, Millard. Why the plaintiff and defendant number 1, 3, and 4 entered into a terms of settlement to the exclusion of me, Millard, my client, and 6, 7, and 8.
So it is your conditional acceptance. Your
Millard,
acceptance of the
they
terms
have
of
their
settlement is a conditional acceptance.
I will pay and I should get my property, Millard. It should be a symbolic possession, Millard. It has been already occupied by some tenants. The tenant should be given a letter or an order be passed, Millard, by this honorable court that from this day onward, I am in possession and I am the owner of that property. Millard, why they are entering into this kind of new terms of settlement, the plaintiff and 1, 3, and 4?
No, you see, whoever is in possession, their possession cannot be disturbed, save and except by due process. Whatever is there is there.
Millard, that's the reason I'm asking for.
Only it is partition by myths and bounds.
My lord.
And how far these terms of settlement will apply, that is to be considered.
My lord. Now, Millard, the plaintiff is asking for their share, saying that keep the entire partition suit pending, give me my building, will go away. Millard, this is unnatural to the partition suit, Millard. This cannot happen. Millard, why they have entered into this? Because it's a standalone building and we are stuck with 2 floors of a building with other defendant. Now, a standalone building where maybe, Millard, income tax liabilities or KMC liabilities are accumulating. It is accumulating in our share also. Everyone's share. Now, why we are saying this, Millard? They will take away the building They will sell off their shares. It's an engineering center, and they'll just go away.
But you see, so far the other parties are concerned, they don't have any liability with regard to that building.
No, my lord. The plaintiff has agreed that they will pay off
all the liability with regard to that.
with regard to that.
So that is there. So whoever comes, the X7 except the plaintiff, nobody will have the burden to pay off the liability.
My lord, if that can be dictated by, or an order can be passed on this, what has fallen from your lordship, my lord, then we are also willing to pay our shares. Why we cannot pay our shares?
Your apprehension is the plaintiff will sell and go. See, so far that plaintiff's position is concerned, you see, it is the burden upon the plaintiff or the third party, whoever it is. So it is not the burden of the other defendant. So even if the plaintiff goes away, it is up to the third party, not upon, it will not fall upon you.
Milord, the same should follow for us also. Milord, if anyone purchase my shares, it has already been partitioned with meets and bounds, Milord. So if anyone takes my share, same thing will follow with me. It is not different for plaintiff, Milord, and it is different for defendant. Something else goes for plaintiff and something else goes for defendants, Milord. Milord, the same goes for us. Why, Milord? Milord, they are making this application in connivance with 1, 3 and 4.
Terms of settlement must specify the exact dues.
It is not there, Milord. It is not there. The new terms of settlement is not there, Milord. Does not contain any specific dues, Milord.
But you see, so far the dues and allotment of the share is concerned, so far one portion goes, that goes for good. So no dispute with regard to one portion.
No dispute with regard to one.
With regard to other portions.
But Milord, in a partition suit, I just asked myself, in a partition suit, Milord, can this order be asked, Milord?
If there is a terms of settlement?
Terms of settlement not between all the parties, Milord.
But how far your client accepts, that is to be considered?
Certainly, Milord. Milord, what my client accepts, Milord, it's narrated in page 11, Milord. We are saying that we can only agree to this if every party gets either through a special officer, receiver, or anything, Milord. If we are allotted our shares and we can clear off our dues, we are ready and willing to pay our dues, entire dues, Milord, relating to income tax, relating to corporation dues and gratuity within a period of, Milord, 2 weeks. We are ready and willing to do that, but we don't know where to pay. If there is a preliminary decree relating to my share, Milord, and already it has been declared of this property, I am supposed to get 2 floors, Milord. Then why I am not getting it, Milord? This is what my simple question is.
You have to get 2 floors. No, in the terms of settlement, no allotment of your portion comes.
In the new terms of settlement, Milord. In the old terms of settlement, everyone allotment is done, Milord.
Now the plaintiff is insisting on the fresh terms of settlement.
On the fresh terms of settlement, Milord, which cannot be, Milord, to my limited knowledge, Milord, which cannot be paid, Milord, by the plaintiff. Milord, at a stage when the entire shares of all the defendant and plaintiff has already been decided and already been declared, Milord, that who is supposed to get which portion of which property, then at this stage, Milord, all the plaintiffs and the defendant should get their respective shares, Milord, and should clear off their dues.
Now, what else to be done? Now, suppose that terms of settlement, according to you, is incomplete to some 10% or 20%, whatever it is. 80% may be acceptable to. Now, what else is to be done to make that terms of settlement a complete for disposal of the suit?
For disposal of the entire suit, Milord, partition suit.
Ultimately, that is suit has been disposed of.
Milord. Then what to my limited understanding is, Milord, if my lord appoints someone to collect the dues, and if not collect the dues, Milord, then according to the preliminary decree, let us be allotted to everyone, all the co-owners, all the co-sharers of the property, that you have the right from this day onward, you are the owner of this portion of the property, Milord. Now, what will happen, my lord, why it can resolve the entire dispute, then that owner of that portion of the property will have the right to apply before respective be it corporation, my lord, or the IT department, to say that what is my proportionate share of the taxes of this building. Then they can clear off the dues, my lord. If the plaintiff says that they will clear it off within 6 months, it will never happen, my lord. It will never happen. It can only be happen if respective properties shares is allotted to all the defendants and plaintiff. Then they will have the right, after armed with my lord's order,
See, that
to approach.
preliminary part is over. Preliminary decree is already passed. So whatever shares are declared.
Declared.
Now, on the basis of the preliminary decree, there should be partition by metes and bounds, not by terms of settlement. Initially, the court directs the parties to enter into an amicable terms of settlement.
And
if the parties fail, then the appointment of a commissioner.
And we entered into the terms of settlement.
So that terms of settlement has been entered into, but only thing is this: one of the party is left out, who has agreed to accept the terms of settlement on this condition.
My lord, only my lord, 3 and the plaintiff, 3 defendants and the plaintiff.
Yes.
My lord, me being the defendant number 2, and 6, 7, and 8, they are excluded from this new terms of settlement.
So defendant number 2 has
not been made party to the new terms of settlement.
You are opposing to this application.
To this application.
Only defendant number 2.
Defendant number 2. 6, 7, and 8 is also there. The entire dispute, my lord, can be summarized into this, that whom to pay the dues, my lord. Everyone can get their share. Everyone can, if everyone gets their share, my lord, they can apply before the statutory authorities that what is the dues relating to my proportionate share. Then they can clear off the entire thing. But because of this, no one wants to pay at this stage. But this is my humble submission, my lord, to this extent that this application is unnatural to the partition suit, my lord, and should be dismissed.
Yes. Now let me hear the other defendant.
Much obliged.
At simpliciter, my lord, partition suit filed. Thereafter, a terms of settlement entered and executed between parties. My lord, preliminary decree passed. Now, what just fell from your lordship, on the basis of preliminary decree, the suit has to come to a finality. Now, if I take your lordship to the preliminary decree, my lord, why this application should not be allowed, my lord? My lord, if your lordship kindly comes to page 55, the preliminary decree starts. Now, my lord, after the cause title, the few paragraphs I'll indicate your lordships. My lord, I am representing 6, 7, and 8, my lord.
Yes.
My shares are there indicated, page number 62, internal page 8 of the preliminary decree.
Yes.
My lord, the defendants, my lord, 6, Miss Sarveen Abu Bakr, 2.083%, Miss Saria Abu Bakr, and Miss Sarnaz Abu Bakr. My lord, the collective percentage is 8.1. It's a very nominal share, my lord. Now, certain clauses which are there originally in the, my lord, the terms of settlement, which are incorporated in this preliminary decree. Now, if your lordship will kindly see, take up the clause 4, just bottom part, my lord. In respect of the suit properties, Faraday House, 71 Benting Street, Engineering Center.
That is page?
My lord, page, same page, my lord, 62, internal page 8 of the preliminary decree.
Yes.
My lord, lordship found it, my lord. My lord, clause 4, in respect of the suit properties, just below my shares are indicated, my lord. In respect of the suit properties, Faraday House, 71 Benting Street, Engineering Center, 6 Western Street, which the plaintiffs are claiming, AC Mansion, 72 Benting Street, and Benting House, 73 Benting Street. There is approximately 1.22 rupees 1 crore 22 lakhs due and payable to the Kolkata Municipal Corporation. Now, my lord, there is a statement, particularly, my lord, a paragraph in the terms of settlement. So, lordship will found that there are certain dues. My lord, this preliminary decree was passed in 2016. And I'll take up, I'll show your lordship, my lord, the order passed by Justice Krishna Rao when His Lordship appointed the Special Officer Commissioner. My Lord, presently the due is more than 4 crores. My Lord, subject to correction, my Lord, the bank accounts have been attached. My Lord, till date, we are not clear how much dues are there. My Lord, unless and until the dues are cleared, my Lord, I am shareholder of in respect of 8.1%. I cannot calculate the dues unless and until I am aware of what is my actual dues. Even if I approach the Kolkata Municipal Corporation, they are not going to disclose me what is my actual due, because it is in respect of 4 properties or individually in respect of
Dues can be ascertained, assessed with regard to the entire estate.
my lord.
As
And
is
for that purpose, my lord, the receiver was appointed.
yes.
If your lordship kindly takes up order 26, my lord, rule 13 and 14. My lord, that's a statutory provision. My lord, CPC.
Yes, you place it.
My lord, it says, my lord, rule 13 says, commission to make partition of immovable property.
Yes.
Where the preliminary decree for partition has been passed, the court may, in any case not provided for by section 54, issue a commission to such person as it thinks fit to make the partition or separation according to the rights as declared in such decree. So, my lord, the rights are declared in decree. My lord, what we 6, 7, 8, and my lord, my learned friend representing defendant number 2 are praying, my lord, appointment of a special officer, which is already there. My lord, Mr. Jishnu Chaudhary is already there, my lord. He has been appointed. My lord, he has failed to perform his duty due to certain reason. I'll place that report to my lord, which I have annexed to my affidavit in opposition, my lord.
Yes.
And it will be very much clear to your lordship who are interested and who are not. My lord, in a partition suit, my lord, all plaintiffs and defendants are plaintiffs to be considered as plaintiffs, my lord. No one has a greater or lesser interest in the property. Whatever their shares are, my lord, they are entitled to that. Neither I can claim, my lord, plaintiff's share.
Question is, well, let me see your affidavit in opposition.
My lord, it was affirmed on 1st of April 2025 by Saria Abu Bakr. Well, straight away I'll take to your lordship to page 31, report of the commissioner, my lord. My lord, annexure R3, page 31.
Yes.
My lord, the present suit is for partition. There is preliminary decree dated 22nd January 2019. The preliminary decree is on consent of the parties. By an order dated 12 September 2023, passed in GA4 of 2019, the undersigned was appointed as Special Officer Commissioner. The undersigned was required to comply with the preliminary decree and also collect rents and incomes from the properties for clearing all the dues of the joint estate, and after clearance of the dues to hand over possession of the respective shares of the parties for effecting partition in terms of the preliminary decree. So, my lord, it is very much clear why the special officer was appointed. By further orders dated 26th April and 18th July, time was extended by the Honorable Court to submit the report prepared by the Commissioner. It became evident immediately upon my appointment that proceeding strictly in terms of the preliminary decree would not serve the purpose, since in such event an enormously long time would be taken for the liabilities to be repaid from the rents collected. The defendant number 1 and 4 were interested that the matter be not resolved, since they are collecting the rent and are in control of the properties. It is their intention to delay resolution of disputes as long as possibly and continue to enjoy control over the property and its accruals, to the exclusion of the other co-sharers. Initially, when I had served notice and wanted to visit for the purpose of finalizing the method of collection of rent, the defendant number 1 to 4 agreed to a settlement. On this aspect, they were able to waste some time. till I become insistent on proceeding when the defendant number 4 produced a memorandum of fees issued by me for an appearance in a contempt proceeding in which I had appeared for them. I immediately recused. The Honorable Court thereafter directed me to proceed. This time around, the defendant number 1 and 4 to engage in apparently serious discussions for settlement and managed to waste a lot of time. All parties requested me to attempt to settle the matter. I have put in necessary effort. A document containing all terms of settlement was also prepared. The defendant number 1 and 4, however, ultimately did not agree to settle. Now, after filing of this report, suddenly they agreed, my lord. In the exclusion 1 and 4, my lord.
Earlier, they did not want to settle.
No, my lord.
You
My
are
lord,
representing
several.
2 to 6.
My lord, I am 6, 7, and 8.
6, 7, and 8.
There is
1
nothing
and
against
4.
me. 1 and 4, my lord. Specific allegations against 1 and 4 because, my lord, they are in possession. It is relevant that the defendant number 1 does not appear himself, but on his behalf, his representative 1, Rakesh Agarwal, appears. Rakesh Agarwal appears to have purchased a specific portion of the property by a registered deed of conveyance from the defendant number 1. Whereas, I'll show your lordship, in the preliminary decree, there is a clause related to preemption, my lord. Without offering the other co-sharers, my lord, one cannot sell his portion of property, my lord. My lord, the next page. Upon the attempt at settlement not fructifying, it became necessary for me to recuse. I have personally interacted with all the parties exhaustively over the last 6 months. It would, in my humble submission, be improper for me to now act as a commissioner of partition or a special officer in this matter. I therefore pray that I be discharged. My lord, now thereafter he has not been discharged. He is still receiver commissioner in this property. My lord, if he is not willing to act as a receiver, my lord, lordship will appoint somebody else. My lord, it is on. He's still the receiver commissioner. He's not, my lord, after filing of this report, he's not appearing before your lordship, my lord. He's not supposed to, my lord, unless and until there is a specific direction upon him.
Discharging the function.
My lord, he has not been discharged by this honorable court. He is not discharging, my lord. After filing this report, he is not discharging, my lord. He tried his best to settle the dispute, my lord, and to comply with the order passed by Justice Krishna Rao. My lord, he has failed, my lord. And while failing, the reason he has indicated why he has failed, my lord. Now, my prayer is limited, my lord. Your lordship, in case the existing special officer receiver is not willing to perform his duties, my lord, your lordship.
What is your stand with regard to the terms of
My
settlement?
lord, my stand with regard to this particular application is to appoint a special officer receiver through the existing receiver special officer or through any other person which your lordship wants to appoint, my lord. Through him, my lord, kindly direct him to comply with the preliminary decree, my lord. Because, my lord, one in a partition suit, one cannot travel beyond the preliminary decree.
Yes, definitely.
My lord, there are contradictions, my lord. I'll show your lordship. Lordship, kindly give me an opportunity. I'll show your lordship.
You see, after passing of the preliminary decree, if the matter is amicably settled, the
My lord,
final decrees are passed.
Between all parties.
Yes, but if there is no such, then the question.
And while, my lord, drawing up particular terms of settlement, it has to be in conformity with
the initial stage after the preliminary decree was passed.
In 2016, my lord.
So
19, my lord.
The commissioner was appointed.
In 2024,
in the event
my lord.
Amicable partition is done, well and good. Otherwise, by meets and bounds.
My lord, there is no requirement of meets and bounds, my lord, because, my lord, already the parties have settled. They have already demarked their portions. There is no requirement. If your lordship kindly takes a page, my lord, 21 of my affidavit in opposition. My lord, this order was passed by Justice Arindam Mukherjee in an application filed by the plaintiff for appointment of a receiver. My lord, plaintiff have filed 2 applications for appointment of receiver. My learned friend representing defendant number 2 have filed 1 application for appointment of receiver. Similar prayer, my lord. During the course of 2019 till 2024, my lord. Thereafter, all three applications were consolidated and the receiver was appointed. Now, one fine morning, now they have selected few defendants and they have come up with the terms of settlement. They wants to their share of property from the estate. There are several other preconditions which have to be complied with. Well, if your lordship kindly see, my lord, while disposing of this application, my lord, specifically at page 22, his lordship has observed, I find that the properties have been allocated to the parties under the preliminary decree. The only part left out is vacating the portions under the occupation of the respective parties and shifting to the portion allocated to them under the preliminary decree. This part has to be done, my lord. This part is left out. It's a property full of tenants. 4 buildings full of tenants. No one resides there, my lord. None of the plaintiffs, none of the defendants. That's why his lordship has further observed, it is made clear that vacating the portion under occupation of the parties and shifting to the allocated portion should be done simultaneously as far as practical to avoid any multiplicity of proceedings in future. My lord, I consider your lordship allows their application, my lord.
Now, regarding that building,
my lord,
which is the terms of the settlement, was that allotted to the plaintiff under
Yes,
the
my
preliminary decree?
Admittedly, that building was allotted to them, my lord. I cannot lie before your lordship, my lord. That was allowed to them. I have admitted that in my affidavit in opposition also. That is there very much clear in the preliminary decree. Who will get what? But my lord, it has to be.
Has the plaintiff or the parties exceeded their claim as made in the
No, my lord.
decree?
But my lord, the precondition is payment of municipal taxes, which they have not done, which none of us, in fact, why should I preclude myself, my lord? I have a limitation because, my lord, I am not aware of what is the actual due. That is within the knowledge of defendant number 1 and 4. Who are the signatories to the AC estate? My lord, a estate who collects the rent.
Yes.
So, my lord, unless and until a person is appointed, my lord, it is impossible.
What is the condition regarding payment as observed in this order?
My lord, nothing paid.
No.
My lord, with regard to their statement,
been
which yes, my lord, may I show you, lord?
So, Mr. Bose's submission was recorded that there has been an agreement between the parties.
My
That
lord.
is the former agreement, settlement.
No, my lord, this is a present settlement.
No. 2019 order. The learned judge records on the submission of Mr. Bose that yes, there has been an agreement between the parties and 50% of the area municipal.
Yes, my lord, that was the terms of
paid.
settlement based on which the preliminary decree was passed. That was the terms of settlement based on which the preliminary decree was passed. Now, if your lordship kindly comes to the present day terms of settlement, my lord, they have indicated at page 81, my lord, internal page 11 of the terms of settlement. My lord, the application GA 8, my lord, page 81.
Yes.
My lord, lordship will see that, my lord, the paragraph 12, the parties further agree that the following are the liabilities of each of the parties in respect of the AC estate, my lord. Gratuity, income tax. And if your lordship, my lord, there is no whisper of municipal taxes, although this is restricted to AC estate only, my lord. Still, your lordship will kindly my lord, page 80, para 10. The defendant number 1, 3, 4, and 5 shall within the next 6 months from the date of acceptance of the present terms of settlement make payment of their proportionate liabilities due in respect of premises number 71, 72, 73 Benting Street. Malad, there is no consolidated amount available in respect of the 4 properties. My lord, what are my dues? My lord, whom am I supposed to pay? My lord, that is also, if your lordship kindly takes up my affidavit in opposition, and my lord, page 28 of my affidavit in opposition, my lord, his lordship, Honorable Justice Krishna Rao has observed the defendant number 4 submitted that the following dues are outstanding with respect to suit properties. Municipal taxes 4 crore 13 lakhs 9,662.70, income tax 68 lakhs 7,367, staff gratuity 10 lakhs 8,600. The defendant number 4 has filed statement for account for the year 2018-19 and submitted the defendant has complied with settlement arrived between the parties and also complied with the order passed by the court dated 28 November 2019. The court has considered the statement of account submitted by the defendant number 4, but there is no breakup of the amount shown in the said account. This court finds that the said statement of account filed the number defendant number 4 is not an accurate one.
Page?
My lord, page 29 of my affidavit in opposition. My lord, para 11. 10 and 11, my lord. My lord, there are ambiguities, my lord.
Yes.
It is very much clear that the statement of account filed by the defendant number 4 is not an accurate one. And my lord, may I place it once again, my lord, the condition which are there in the preliminary decree
Yes.
My lord, if your lordship kindly takes up the application page 65.
Yes, page 65 is the preliminary decree.
My lord.
Yes.
I'm placing para 12, my lord. The third paragraph from the top.
Yes.
After the entire dues of Kolkata Municipal Corporation have been paid, the plaintiff shall be exclusively entitled in severalty of joint owners to the said property known as Engineering Center. So, my lord, after payment. And similarly, the defendant shall be entitled in severity of joint owners to the remaining portions, namely Faraday House, 71 Benting Street, AC Mansion, 72 Benting Street, and 3 Benting House, 73 Benting Street, and all, and will execute the necessary documentation and finalize their respective shares. So, my lord, after payment of municipal dues, not before the payment of municipal dues. And what they say, my lord, immediately they'll get possession.
At present, it is in possession of
1 and 4.
this Western state.
All 4 buildings. Defendant number 1 and 4.
All suit properties.
All suit properties.
And 1 and 4, 1, 3, and 4 are the parties to the settlement.
1, 3, 4, and 5, my lord.
They are the parties to the
The
settlement.
parties to the settlement. My lord, the next clause, if your lordship kindly takes up, my lord, 13. After the dues of Kolkata Municipal Corporation and other dues in respect of the suit property have been paid, my lord, other dues in respect of AC estate, my lord, income tax, gratuities. The authority of the said forum, my lord, said four buildings, said firm, AC estate shall be automatically seized and the parties will be entitled to enjoy their respective shares in the said properties in accordance with the said memorandum of family arrangement. My lord, the family arrangement is still available with the plaintiffs and the defendant's advocate. That is recorded in this particular preliminary decree, my lord. So, my lord, there is a precondition, my lord, of making payment and then getting the possession. So, unless and until your lordship appoints a special officer or receiver, my lord, it is impossible to come to a finality.
The position remains the same. Whoever was in possession, they are continuing in possession.
My lord, my difficulty
Nothing has changed.
Nothing has changed, my lord. My lord, my difficulty is, my lord, the plaintiff takes the Western Street building, my lord, engineering center. Now, my lord, I remain there. Now, they say
the appointment of the special officer was made in 2023, but the dues has not yet been ascertained. The dues are not yet been ascertained.
they have not cooperated, my lord. But that is very much clear from the report submitted by the special officer. My lord, it is their responsibility who takes care of the entire building. We are not in possession. They are managing the entire estate. My lord, defendant number 1 and 4. Unless they come forward and, my lord, they disclose what are the actual dues, my lord, it is not possible. Only your lordship can appoint a special officer. He can go and verify the records. There is no requirement. The statute says that your lordship can appoint. And, my lord, there is a receiver who has already been appointed. He has not been discharged.
Justice Arindam Mukherjee's, let us consider Justice Arindam
My lord.
Mukherjee's order. Which page?
My lord, that is page, my lord, starts at 21, my lord.
Of your opposition.
Of my opposition, my lord. Well, it says that this is an application for final decree to be passed in terms of the preliminary decree dated 15th December 2017.
So
Under the state
this order,
my lord,
recorded that there was a settlement.
There was a settlement. Because of that, my lord, the preliminary decree was passed. My lord, there are two settlements, my lord. On the basis
prior to preliminary decree.
Prior to preliminary decree, and this is the recent one which they have executed between the plaintiff and defendant number 1, 3, 4, and 5. Now, my prayer is limited, my lord. My lord, this particular terms of settlement cannot be accepted, my lords, because this is the certain clauses are.
See, it is also observed that since the two groups are primarily agreed upon payment of arrears of municipal rates and taxes.
My lord, everybody agreed. That is there in the
such
preliminary
exercise
decree.
be completed within
Who will, my lord, who will guide us to complete the exercise, my lord? Only your lordship can.
You see, whatever the dues, you see, entire estate dues will be there.
My lord.
Okay. And thereafter, you see, after this
My lord,
allotment, they are
my
also.
lord, if they indicate, my lord, what are my dues, and if your lordship protects me, my lord, on Monday, my lord, I'll deposit the dues, whatever dues is there. Be it 10 lakhs, 20 lakhs, I'll undertake before your lordship, I'll deposit on Monday. But unless and until, my lord, I am sure, my lord, how much do I have to pay? What amount I am going to pay, my lord? There is no finality. There is no indication. What is the total amount?
So for the order, it states that yes, 50% this.
That percentage is accepted, my lord. I am not denying that they will pay 50% and the remaining defendants will pay the remaining portion, proportionate shares, my lord. So I have a 8%, my lord, share. I'll pay my 8%. But what is the total? What is the total dues?
Yes, balance 50%, defendant number 1 and 4.
Yes, my lord. That according to that terms of
So
settlement.
for municipal tax is concerned.
Yes, my lord.
But so for the other dues, it is also.
No, my lord, that they have indicated in the application, my lord. With regard to the dues of AC estate, that they have indicated. My lord, 81, my lord, they have indicated that I have a 27,858 rupees gratuity dues in respect of one defendant and 1,87,952 rupees in respect of income tax, my lord. And I don't have any other liability. This much is clear, my lord. But with regard to municipal taxes, my lord, now even if I pay, my lord, but I'm not sure that whether they will.
So far the liabilities are concerned with this AC estate, it is there.
This is one property.
Now only thing to be ascertained is the municipal tax.
Municipal taxes.
That is the only thing.
That is the. Well, I'm also interested in getting my share in these properties. It's been there since 2010. The suit is there pending since 2010, my lord.
Yes, record and order. Yes, Mr. Bose, you reply on the next day?
Yes. My lord, the respondent numbers 1 to 4 also has not spoken.
Oh. Anyway, so next day you continue?
Yes.
I hope my learned friend has
Learned advocates for the parties are present.
for the time.
Learned advocate representing defendant number 2 to 4, defendant number 2.
6, 7.
And learned
2 and 6 and 7 and 8 have all.
learned advocate representing defendant number 2. And learned advocate representing defendant number 6, 7, and 8 have concluded their submissions. Fix 1/8/2025
1/8. Next Friday.
for submission of defendant number 1 to 4.
1 and 4, my.
1 and 4 for defendant
One and
number 1 and 4. Let this matter appear on 1st August 2025 at 10:30 AM.
Grateful, man.
Yes, call the appellate sec matters. Appellate sec list কোথায়? আর কিছু না এবার all appellate sec matters.
That to item number 10, my lord.
Then original side.
Original side, my
My lord, I appear for the applicant.
It will be taken up on the next day. 9, 10, I have to take up the appellate side matters now.
As your lordship.
My lord, it is only a short matter, my lord. It is a prayer
Anyway.
for restoration, my lord.
Yes.
It is pending since long.
Item 10.
Item 9, my lord.
Okay.
My lord, the respondent informed that 2 of the defendants have died. So an application for substitution has to be made.
So both parties, you are.
I am for
Yes.
the defendant.
But my lord, the only
Item 10, item 10, let this matter appear on. Item 10.
9.
No, you are for item 9. Restoration
yes,
application is item
Yes,
9.
yes. Item 9, my lord.
Okay. Both parties are present.
Yes,
Lordship.
yes, my lord. I am
Okay.
for the defendant
Let
number
this-
2. 1
Let this
has
matter
expired.
appear on 29/7/2025 at 4 PM.
Lordship. 29.
Item number 10 is here for the item 10.
Then, okay, next day it will be taken up.
As your
Let it be not today.
short matter, my lord.
Anyway, I have to take appellate side matters, so come on the next day, I shall take it up.
My lord, we will not be taking audio side now.
No, no, no.
Slip down. Figure number 9. Item number 1. आपका भी वही है. I'm petitioner for the case. Please release the case. I said release the case.
Yes.
I said release the case.
Why? Under what under what law?
I have already submitted a complaint before Chief Justice,
Yes.
and I am going to submit a detailed complaint about the practices of this court to the judiciary and to the Chief Justice again.
Okay,
Please release the
I'm making it not today. Come with an order from the
No.
Chief Justice, I'll release.
I do not want this court to do anything for my case. Please release the case.
Yes, record an order, please. The petitioner prays for release of the case as because a representation is made to the Honorable Chief Justice.
No, because this court is not giving justice to my case.
Yes.
Court is opting for malpractices.
Let this matter appear on
This camera recording will always be there.
8
What I am communicating to the court.
2025 for necessary orders from the Chief Justice. I am keeping it on 8. If the Honorable Chief Justice passes any order for release, I'll release it.
What is the date, sir?
8th of August.
Please release the case because it.
You have made a representation. Let orders come. I shall.
With regard to the Jana,
Okay, come on 8th. Come on 8th.
I am on for the no, I am for case number item number 2 only.
Oh, item 2.
Yes.
Okay.
The respondent advocate's on record is
Sivastava.
no, Syashish Jana.
No, item 2.
Item 2 too. Appellate side. Village not
Item 2.
CO 3338 of 2020.
Yes.
Yes.
I believe. No, you are for the petitioner or respondent?
Respondent.
Okay, I'm passing it over.
My lord, I am appearing for the petition.
I am for the opposite party, my lord, petitioner, opposite party. So my lord have already decided the issue.
আমি তো বলবো
Whose application is this?
Let him start, my lord.
Okay, can 1.
Let him start.
Can 1 is your application.
This is
application. How the recalling is maintainable, my lord, I can't.
Okay, just a minute.
ঠিক আছে। Let him
Can 1 of 2025. Let me see the application.
আরম্ভ করো না ভাই, তুমি আরম্ভ করো।
Yes. What is
Lord,
this application for recalling?
I have come before your lordship for recalling the judgment and order passed by your lordship. On the basis, I will show before your lordship some portions of the judgment of your lordship. Then your lordship can decide whether this order need to be recalled or not. That is up to your lordship. My lord, this is the Verifiable Service Act to kindly comes to my lord, page 47. Your lordship judgment, page 47. If I can satisfy your lordship recall, it is up to your lordship. Page 47. Judgment. Your lordship has started the case with the saying, the petitioner before this court is a claimant. Petitioner before the court, he is not a claimant. He is nobody.
8th August. No.
Nobody. Inasmuch as suit was filed by one Prafulla Ghosh. By one Prafulla Ghosh in 2004. On 26th of April 2004. The suit was filed on 26th of April 2004. 1 year after the transfers. On 20, I am giving emphasis. On 28th of April 2003, Prafulla Ghosh transferred the property by a gift to his son, a registered document before the donor and donee, accepted by the donee.
Yes.
And having been mutated and records having been changed, he filed a suit, that Prafulla Ghosh, on 26th of April 2004 against me, between the owner and the tenant. The suit was decreed. Prafulla Ghosh died on 16 May 2020. Execution proceeding started by Prafulla. Subsequently, Vishwajit Ghosh wanted to be party. This Honorable High Court
You have
said,
stated this in your applications. In your recalling applications, you have stated all these things.
Before your lordship, kindly see the judgment.
No. Let us come to your recalling application. What are your grounds
Yes,
in your
kindly,
recalling application?
my grounds, my lord, kindly see. First of all, you will also kindly see. My lord, kindly see paragraph 2. Prafulla Kumar Ghosh had no locus standi right or title whatsoever to file a suit against the defendant, claiming himself as the owner of the suit property, inasmuch as he had already transferred this property in the name of his son Vishwajit Ghosh on 28th of April 2023. 2003. The suit was filed on 26th of April 2004 when he was not the owner of the suit property. Your lordship has considered in your lordship judgment, but your lordship has considered this point. Page 48 of the judgment. Your lordship considered this point, but no finding was recorded by your lordship whether a suit is maintainable. If the suit is not maintainable, whether decree will be and fraud has been practiced by Prafulla Kumar Ghosh, claiming himself the owner when he was not the owner, whether decree can be sustained, which is a nullity in the eye of law. You will also kindly see page 48. It was the contention of the opposite party judgment debtors. So the decree holder has obtained the ex parte decree against the judgment debtor opposite party on 2nd February 2006. But the opposite party has executed a registered deed of gift. My lords, finding kept in favor of one Bishwajit Ghosh in respect of suit property on 28th of April 2003 by deed number 3288 and the decree holder, namely Prabhu Kumar Ghosh, without disclosing the said fact of execution of one deed of gift in favor of Bishwajit Ghosh in the year 2003, continue to the title suit number 62 of 2004 and obtain ex parte decree against the judgment debtor. As such, the decree holder has no locus standi to file TS number 62 against the judgment debtor, as the decree holder was divested of his right in respect to the suit property. My submission that you lordship kindly consider this aspect only. On this aspect, and secondly, I am showing other paragraphs also, your lordship judgment. Your lordship kindly consider the same and pass the necessary order. Then, my lord, kindly see, judgment, kindly see, my lord, page 49. Bottom.
Yes.
It is the contention of the petitioner's judgment, page 49. Page 49, my lord judgment. Kindly see. Bottom. It is the contention of the petitioner judgment debtor that the said Prabhu Kumar Ghosh has obtained the decree by practicing fraud upon the court, as the suit property has already been transferred to the opposite party decree holder, namely Prabhu Kumar Ghosh, by that time to one Bishwajit Ghosh, and the decree holder had intentionally withheld the decree deed of gift from the court. And court has passed ex parte decree in favor of the opposite party decree holder, in spite of the fact that he had no right title over the suit property. Petitioner has adduced evidence, PWS ex parte, he marked as evidence such and such, certified copy of the deed for the year, Exhibit 1 in support of the case. Thus, considering the unchallenged testimony of petitioner, judgment debtor, the documented evidence produced by the petitioner being the registered deed of gift for the year 2003 in favor of Bishwajit Ghosh made by the opposite party decree holder is sufficient to hold, my lord kindly consider, sufficient to hold that the opposite party had no right, title, interest over the suit property, when the title suit being number 62 of 2004 has been instituted by the decree holder against the petitioner judgment debtor. Moreover, the ex parte decree that has been passed against the petitioner is null and void.
Is it findings of the court or submission?
My submission,
Yes,
it is,
yes.
no, it is my submission, but
Yes, that is recorded.
kindly, yes, these are the this is the facts. Kindly consider, my lord, this is the narration of facts, admitted facts.
No, I have decided this issue. Why are you
I have
again
not,
coming?
you have not decided the issue.
I have, whatever is required, I have held.
Your
Why
lordship,
again you have come this
no,
with
no,
this
your lordship
application?
has not decided the issue. Can you see the finding of your lordship? Had it been decided by your lordship, I would not have come. Fundamental question has not been decided by your lordship.
Yes, which page?
Kindly see your lordship judgment findings. Kindly see your lordship. Upon page 61. Having considered the facts and circumstances of the case. 61.
Yes.
Having considered, last paragraph, having considered the facts and circumstances of the case and the submissions made by the petitioner judgment debtor, and that decree was suppression of material, there was suppression of material facts when the order dated 31st of October 2020 was passed. The order dated 31st of October 2022 and its connected order dated 16/12/2022 and 9/1/2023, 20th of June 2023, 20th of September 2000 are hereby recalled. The name of the petitioner in orders dated such and such in the constituted of the order shall be deleted. In any space in the name of petitioner shall be written as Prabhupada Kumar Ghosh since deceased.
Yes, that
Now,
is the earlier order. Earlier order.
earlier order. Now, your lordship is considering your lordship judgment. Thus, upon perusal of the order dated 18/10/2023, it will appear the order directing the implement on name of Vishwajit Ghosh. The petitioner herein was recalled on the ground of suppression of material fact. But the issue as to whether Vishwajit Ghosh, the petitioner, is the legal representative of the decree order was not decided on merits. This is your lordship finding. There is no question of decision of. There is no question. That is our submission now before your
So
lordship.
if I have heard on any points of law, there is a higher forum. Recalling is not maintainable. If the court has heard on the points of law,
Points of law is.
so you go before the higher forum.
Points of law is order obtained by fraud.
Is this order obtained by fraud?
Fraud.
No, this court, the order.
Order obtained by fraud.
Yes.
That was not considered by your lordship.
No, question is whatever I thought fit, I have gave my reasons. If you think that this court has erred on the points of law, the higher forum is there.
Higher forum.
You recalling application, how it is maintainable?
Question will come before the higher forum. I know that. I was appearing. Question will appear before the higher forum on the ground. Whether this point was argued or not, and what is the finding of the High Court.
Anyway, your
lordship has not recorded any finding.
Your submissions were considered, and thereafter I have
No,
gave my reasons.
no considered.
No, your submissions
No consideration has been made. No consideration has been made. As such, the higher court will ask me the question that whether this point has been considered by the High Court. Your lordship has not considered.
I have recorded your submissions. Okay.
No, on the your lordship kindly 2 dates your lordship cannot ignore. From your lordship, the narration of facts is the admitted fact. Your lordship relied on the narration of facts. Deed of gift was made on 2 dates. This is a constitutional court. Your lordship will see whether injustice has been done to the petitioner. Kindly see whether court can pass a decree. He transferred his property 2003.
No, those points are open before the trial court. You can take these points before the trial court. Why this court?
What can I? Decree has been passed.
Very well. You go for setting
No,
aside
your
the decree.
lordship has said that you go for execution.
No. Question is no question of execution. You proceed before the court, substitute the legal heirs and proceed.
I cannot substitute. There is no legal heir.
You substitute the
No,
government.
no, not substitute.
No. If no legal heirs,
Cannot be substituted.
whatever is, you see, just if nobody is there, you cannot obtain a degree. Suppose a person is dead, you have to bring any government authority or any special officer of the court who will represent the estate of the deceased person.
No, this is
No question. You see,
it will not come.
just a person is dead
No,
and you
in
just
the
obtain a
suit
degree.
it will not come. The Registrar General or Administrator General will not come in the suit.
You see, just like that,
Tenancy agreement. No,
just like that, you
this
can't.
is not a public property.
No question of obtaining a or decree against a dead person. You are proceeding against a dead person. How that is permissible?
I did not proceed.
You see, you
I
have
did not proceed.
when a decree.
It is he, Prabhupada Ghosh said.
No, you see, you obtained an order to get the decree nullified when the decree holder is dead. But during the time of the decree holder's existence, you did not move.
No, we have challenged. As the trial court said, your lordship has set aside that particular order. Trial court said decree has been obtained by practicing fraud.
Very well, but
your lordship has
but you
set aside
see,
the order.
Why? You see, many things can be said against a dead person.
Your lordship has set aside the order.
Against a dead person, many things can be said. So, but let somebody represent, let them justify, let the legal heirs.
There is no question of representation.
He
is not the heir.
I have directed, let it be considered whether he is a legal heir or not.
Why it will be considered?
So I have given the reasons why it will be considered.
Kindly consider whether this is proceeding continuation of suit. My lord, kindly consider one aspect of the matter.
I can't consider. I have not seen. I have not seen that an order is passed against a dead person. When a person is dead, a petition is made, an order is passed that this order is a nullity.
My
I have not
two-
seen such type of orders.
Your Lordship is proceeding in another way. My first submission, fundamental question. He was not the owner.
That I will not go. In
Oh, you can't
227,
facts.
in 227 jurisdiction, that
facts.
can be gone into.
Narrated the facts, page 48.
I have not come to the conclusion that
No,
this
no,
person is the owner.
sir, we have come before Your Lordship. Your Lordship omitted this particular consideration.
This court in 227
Because Your Lordship 227 code.
227, this court will not.
Yes,
That
227
has to
bound
be.
to consider the.
No. Whether he's a, you see, that has to be adjudicated on evidence whether he's an owner or not. Why I should
There is
consider
no
that?
admitted fact. There is no question of evidence.
How it is admitted fact? The person
Can't
is dead.
see whether any demand has been given to the. Whether this has been challenged by them, but the deed of gift.
That
Court cannot challenge.
In 227,
They have not challenged.
that can't be gone into.
Let them show a particular document. This particular, they say that before this particular filing of suit, deed was not executed. I have annexed the
So
deed.
instead of
I have
giving him,
annexed the deed.
instead of giving him opportunity to agitate here, he will agitate before the trial court.
Trial court, executing court, my limit
Not executing
jurisdiction
court,
is
that-
limited.
That miscase, you have filed a
No,
miscase.
no, Your Lordship, order is.
No. You have filed a miscellaneous
Executing
case.
court, order is limited.
No question. You see,
There
but
is no question of year.
question of you have filed a miscase to set aside the decree. We on the ground of nullity. That miscase was allowed against a dead person. So I have granted him
No,
opportunity.
I am not that person again. I am not against the dead person. Your Lordship is not considering my submission. I am not against the dead person. I am submitting on the basis of the right to file suit. Whether Prafulla Ghosh has right to file suit.
This court can't go into that in 227 jurisdiction.
That is the facts. That is admitted facts. There is no there is no denial. No denial. Kindly, Your Lordship, kindly see narration. Whether Your Lordship is recorded any denial. Kindly see Your Lordship's order. Whether any denial, let him also deny the same. There is no finding of Your Lordship on the facts. There is no denial by the other side also. Cannot be denied. Deed is there. Deed is annexed with the document. Deed is there. We have got the deed also. If on the fraud, a suit is decreed, in 227, Your Lordship can satisfy the entire proceeding. This is not 151, 115. Before Your Lordship, we are under Article 227 constitutional point. Whether on fraud, the decree can be sustained. Whether there can be execution. Kindly consider the judgment, then Your Lordship reject my application or allow my application. That is up to Your Lordship. Kindly consider the law of Supreme Court, which has been laid down. First of all, Your Lordship, kindly consider 226.
No, all these were considered on the last occasion. You submitted this judgment.
No.
No, in recalling application
last
scope is very
occasion I
limited.
submitted 2 judgments.
You recalling application scope is very limited. Okay.
No, recalling
No,
petition,
this is not an appeal. You see.
recalling, no, this is not. I cannot appeal. Before the High Court, appeal does not lie.
So this is not an appeal.
No,
This is
I am not
recalling. The scope
question
is
of
very
law,
limited.
jurisdiction. I can come under
Okay, come with your written notes of arguments.
superintendence.
Come with your written notes of arguments on the next day.
Your Lordship is exercising superintendent's power. Kindly see 227, not 115. Kindly see what is the power, what is the 227 said under the Constitution. Kindly see 227. What is this? What is the power? I will show you, Lordship. Power of superintendence over all courts by High Court. Every High Court shall have superintendence over all courts throughout the territories in relation to which it exercises jurisdiction. Your Lordship exercising jurisdiction on a order where it has been held. The suit has been filed by exercising fraud, and the decree was obtained by exercising fraud. As such, decree is a nullity. Subsequently, execution proceeding is a nullity. He came before this honorable court to decide this particular point. We raised the point that suit was not filed by a person who is competent to file. At that point in time, he was not the owner. He is not the landlord, because he has already transferred his right 1 year ago. That is suppressed, and fraud has been practiced and proceeded up to the execution. Whether your lordship will not exercise power on the 227 by exercising superintendence over all courts, not superintending, superintendents. 227 court has got the power. And where there is a fraud brought to the notice of the court, found by the trial court, whether your lordship can ignore this particular
thing
finding.
is found against a dead person. Many things can be found against a dead person. So
I am not saying, I am not telling anything about
entire thing was you said in the trial court before the dead person.
I
The
am
dead
not,
person.
I am not.
The allegation was the dead person
No.
by using fraud has obtained this order. That is your case before the trial court.
Is now his son has come, though he has not been.
Allegation of fraud is against the dead person, not against his son. You have
not against the son.
No, you have obtained.
No, what is the son? What is the status of son? No, he have brought the notice.
You see,
written statement.
Question is, you have obtained an order against a dead person by making allegations against a dead person. That the dead person has obtained the decree by fraud. That was your case. So, if the court has jurisdiction under 227, the court can suo motu take the cognizance and set it right. That no, you cannot pass any order against dead person. Your allegation was entirely against the dead person, not against him. So, how can the court sustain these things?
Court is an institutional suit.
Yes.
Court maintainable the suit. Court will consider.
How can you consider the allegation is made against a dead person? It is accepted without anybody to contest that allegations. Order is passed. How the court can sustain this type of orders?
No, your lordship kindly consider your lordship own judgment.
Yes, I have given the reasons in my order.
This aspect, but no finding has been recorded.
Very well. Whatever you want to submit, you submit your written notes of argument on the next day. I shall consider. Yes, if you want, you submit your written notes.
Well, yes, ma'am. I shall file my written notes. Whether the recalling application after the issue which has been, my lord, agitated right now, that was agitated previously also, and that was elaborately considered by my lord. And
no consideration.
Whether can be again re-agitated.
Court has not considered anything.
Learned advocate for the applicant submits. The matter stands adjourned till A1/8/2025 for further hearing. Let written notes of arguments be filed on the said day.
সেখানে পয়েন্ট নেই, পয়েন্ট নেবেন বরাবর।
Petitioner in person appears. Petitioner in person appears.
I beg to appear on behalf of the petitioner, my lord. This is that matter, my lord, where, my lord, the order 9 rule 13 application was pending, and my lord, the main suit was proceeded. My lord, the opposite parties have appeared, my lord.
You are appearing for?
And for the petitioners, my lord. The opposite parties have appeared on earlier occasion. They have appeared.
So today they are not appearing.
Yes, my lord. That is the difficulty.
Okay, let it be not today then.
Not today, my lord. Interim order is, my lord, continuing, my lord.
It is continuing.
It's continuing. Grateful.
That in view of the subsequent development which has took place, my lordship has already noticed that proceeding has been initiated under the public premises unauthorized occupants act, and ultimately since that was attended, finally I'll have to change the conspectus of the suit by filing proper application for amendment, because now what I was praying before your lordship, I was enjoying that regarding my protection of possession, that is no more there. That's why I will have to bring
Proceedings are pending now.
yes no that has
appeal has been dismissed.
appeal dismissed, so that's why these things has to be brought on record by way of amendment before the trial court. So I do not want to press this with the liberty, so that I can take out proper application before the trial court.
My lord, liberty does not require, my lord.
So
It's revisional application.
no, the cause of action no more remains.
Yes.
Revisional application.
No, what was your application was to set aside the
order appeal of court
the
interim order.
interim order passed by
Yes,
the appeal court.
by the appeal court initially, which has been dismissed by the.
Are you in
enjoying
possession?
that-
You are removed from possession.
By virtue of
No,
that,
he was never in possession.
that my
That
learned,
is his case.
Otherwise, how can you remove him if he's not?
That is his.
if my learned senior friend is disputing
we
that,
have
then let me place.
Yes, please place. And this is
He
asking for
cannot dictate,
declaration. My lord, he is asking for a
submitting before the court.
declaration in a contractual matter.
In a suit
Let
court.
him argue first, thereafter.
Let him do it.
No.
Or if you are wanted to withdraw it.
Whatever I want to submit, I want to submit before the court, not before my learned senior friend. My learned senior friend is dictating something that in what way I should
No. What is your
submit
stand
this.
with regard to
That's
application?
why
What is
I
your
want to
stand?
make my submission.
Very well,
My
very
learned
well.
friend is,
Yes, please make. Do it.
Lord, I wanted to say before your lordship that in view of the subsequent development which has been took place, that I was in possession. Lord, your lordship can see that my possession was being protected by the learned trial judge. Kindly see, my lord. Kindly see, my lord, page 56 once. My learned senior friend is suggesting that my case is that I was never in possession. So whether that is correct or not, my lord, subject to correction by my learned senior friend. Kindly see. It's my suit, my appeal. Page 56 has your lordship got it, my lord?
Yes.
May I place? According to the learned advocate for the Milord, I am placing Milord from the fourth paragraph from the top. It starts with Milord, according to the learned advocate at page 56. For the appellant plaintiff, he is the registered society which is not a profit-seeking one, and accordingly he was allotted 1 acre of land of 1/5 price of such and such on the basis of the letter dated such and such, read with letter dated such and such. The appellant plaintiff is in educational institution which came into possession of the allotted land by virtue of the above mentioned letter, where from prima facie the case established in his favor. The appellant plaintiff submitted further that the respondent is violating in own terms and condition and is contemplating to hand over portion of the property to a third party by overlooking the right accrued in favor of the appellant plaintiff. According to the appellant plaintiff, if the prayer for ad interim injunction is refused at this stage, it may cause irreparable loss to him, and the balance of convenience and inconvenience lies in his favor. I have come to the reasoned opinion that the prima facie case lies in favor of the appellant plaintiff, and there is enough urgency in the matter. I also believe that the prayer for ad interim injunction is refused at this stage, it may cause irreparable loss, and the appellant plaintiff, and the balance of convenience and inconvenience lies in his favor. Under such circumstances, the prayer for ad interim injunction is allowed in the form of status quo, as to the parties to the miscellaneous appeal are directed to maintain status quo with regard to the nature, character, title, possession over the property in question till such and such, and the respondent is directed to show cause as to why. But this was the conspectus when the ad interim order has been passed, my lord, in connection with the miscellaneous appeal. My learned senior friend is suggesting that I was never in possession.
You said order says we cannot give it to other
it's
party.
very difficult, my lord, to argue, my lord.
Unfortunately, what he is reading.
So you have obtained an order of injunction, ad interim order of
And my
injunction.
lord, the little I know,
Yes.
if I was not in possession, what prompted, my lord, the opposite party
No, whatever it is, you see, let us go by the record.
Yes.
So that status quo order was granted in your favor.
Yes.
That interim order of status quo. Thereafter,
if your lordship kindly takes up the order impugned before your lordship.
yes, ultimately, you see, your appeal was dismissed.
Yes. And my lord, there is a proceeding initiated by the opposite party for eviction of mine.
Very well. So
If had it been a case that I was never in possession,
yes,
then there is no question of filing proceeding against me.
I'm not
That's why,
considering.
my lord, what I suggesting today, that in view of that subsequent development that I have been dispossessed by a proceeding initiated by them under the PP Act. So, my lord, new thing has to brought on record. My conspectus of suit has to be changed. So there is nothing to survive in the present revisional application. My lord, liberty may be granted to file proper application before the learned trial judge. Only that.
Record an order.
My lord, before that, Lordship, kindly see the appeals court order.
Yes.
Final order. What he has gone, that I should not hand over the property to somebody else.
Yes.
Now, Your Lordship, kindly see, and that was the order. And now, final order. My lord, kindly come to page 3 of the internal page 3 of the final order.
Page 3. Page 3.
Yes. Page 3 internal order. My lord, certified copy.
Yes, yes, yes.
It should not have been marked.
Point for consideration. That
In
is
the
this.
instant case, the grounds of appeal is just above the grounds of appeal. In the instant case,
Just a minute. Huh?
the certified copy of the order, my lord, that should not be paginated.
That has
That's
not
the
been
idea.
paginated. That has not been paginated.
But
But the last certified copy, my lord.
Last document.
Yes, page 3.
Yes, ma'am.
In the instant case, the learned trial judge.
Trial judge observed that the land in question is a public land. So, while allotment of the same, the respondent, defendant are required to charge an amount of salami, and the allottee has no right to claim any preferential treatment according to the preferential price. Non-payment of the quoted rate at the time when the land is offered can be no way give an accrued right to the appellant or plaintiff for preferential letter of allotment of the same. This was the final observation. He wanted to say that I am in possession. It is a public land.
That's why the proceeding under PP Act initiated, I was not evicted.
Unauthorized person.
So,
and PP Act appeal is already been dismissed. Their appeal.
Yes, record an order.
Let
Learned advocates for the parties are present. Learned advocate for the petitioner submits that as a final order has been passed under the public premises eviction of unauthorized occupants act, this application has become infructuous. Stop. Thus, there is no scope to pass any further orders in this application. Stop. In view of the submissions made by the learned advocates, this petition stands disposed as being infructuous. It is, however, made clear that this court has not gone into the merits of the case, and parties are at liberty to take steps in accordance with law.
I'm extremely
Well, very little matter, but they have to consume more time.
Yes, small matter, more time.
More time. My lord, only thing, my lord, before rising. That is why 3-4 adjournments has been given in the meantime in this matter. Before rising, my lord, one matter. My lord, anyway, my lord, I am grateful to Lord. My lord, before rising, my lord, item number 11. In this matter, my lord, what happened, my lord? This is relating to injunction application. Two courts, my lord, held in my favor. I am the defendant.
So, you have concluded. Only written notes are to be submitted.
Notes of argument only concluded.
Entire thing is concluded.
No, anyway,
Only just summing up and filing the written notes.
notes
Nothing
of
is remained.
argument and before that, my lord, on the earlier occasion, I was not there. My junior argued very nicely, and I shall take not more than 10.
No, argument from your side was over. So,
on reply to 10.
no. Question is the petitioner is to give the reply. You are the opposite party.
I am the opposite party.
Yes, petitioner
They argued. They argued.
No. It is after the reply of the petitioner.
Only point of law I shall make.
No. Question is you have completed. It is only the petitioner who has to give the reply.
Why I am submitting, my lord, before asking, my lord, this matter relating to my lord dismissal of the suit is in terms of the direction of the honorable court.
Whatever you see. On the next occasion,
No,
all parties will come with written notes
no,
of
my
arguments.
submission that this matter has been fixed before the today was fixed for hearing, my lord, dismissal of the suit on the ground of maintainability in terms of direction of this court. And my lord, this matter was pending with the trial court. And in this matter, somehow one of the advocate, due to demise of the advocate, this matter could not be taken up. My submission.
The question is, I have heard this matter at length. You have made your submission. Your junior have made submission.
I am playing people of state that this matter may be taken up after 12th of September.
So in the meantime, whatever.
In the meantime, this dismissal order is
no. Question is, you see, this matter will be taken up. So, okay, let it appear on first as to be mentioned. In the presence of the other side, I can fix the date. Let this matter appear on 1/8/2025 under the heading to be mentioned.
On 8th, my lord.
First August.
First August.
I shall fix a date and I shall try to dispose the matter.
My prayer that if the suit is dismissed, then
do not proceed further. You see, matter is sub judice there. Don't proceed further before the trial court.
The argument is in terms of the direction of the honorable court. Argument is going on. Evidence is going on.
Okay. No.
Already evidence started.
First August. Passover matter ki ache?
Praying for not today.
Yes, Passover matters.
Yes. I'm for the respondent. Respondent's advocate on record is his senior is died today. He's in crematorium.
Advocate on record senior.
No, not senior. Snehashish Jana for the respondent. Item number 2.
Yes.
His senior has died.
What is his name?
Tapush Kumar Mukherjee. He is
Tapush Mukherjee of Bar Association.
yes. Number 2.
Anyway, it will be not today. Let us see on the next day.
Yes. I'm praying for not today.
Yes.
I deeply oblige your lordship.
Yeah, এগুলো নিয়ে নিও।